The DNA evidence and fingerprints. Captain Mamshedi Phineas Maseta testified that he was a senior forensic analyst and in the service of the state. He undergone training when he joined the Forensic Science Laboratory in 2002 with reference to opening of parcels containing biological evidential material, the preliminary testing of body fluids thereof, and DNA techniques which he had offered knowledge and skills for forensic biological analysis. He testified that he received continuous training with the Forensic Science Laboratory up until 2006. He had approximately 25 years experience in the biological sciences. He was responsible for analyzing the DNA results in terms of doing the interpretation of the DNA results. He will then do what they call DNA comparison, where he will then have a case like this one, where he will have the DNA from the exhibit, from the scene, and they will also have the DNA results from the reference sample. The reference sample are the samples that are taken from the suspect or accused individuals. Captain Maseta further testified that he compiled what he got from those particular exhibits when conducting his investigations. The death number allocated for the exhibits from the scene is lab number 217731 of 2014, and lab number for reference sample is lab 126265 of 2016, phosphorus case 636 of 2014. The exhibit and reference samples were contained in exhibit X11 of the record. On the 9th of October 2023, the records depict the following at page 75, line 2 to 4. Captain Maseta, at number 22, which details the description of suspect Mthokozeni Mapisa accused for, was excluded from all the samples. Those quotation. The report compiled by Captain Maseta, exhibit X12 in bracket, contains a table where the relevant results from the exhibit, from the scene and reference samples are compared. The first sample is written sample with an indication of 1, that is swab 1, which has the container number 14DCAH8988 and contained in bag number PA 400 2150107, which was taken from the door handle of bedroom 1. The next exhibit is a head, which is exhibit B on the head DNA, and is analyzed with presumed high friction area. In simple terms, it is a sweat. A head was in evidence seal bag number PA 3000 788535. Captain Maseta received the first reference sample for MZ Mapisa in container number 19DBA F0198 in seal bag number PA 400 4638062. The second sample that he received was from Mthokozeni Mapisa in container number 13DBAD 5906 in seal bag number PA 500 217 6171. On the 9th of October 2023 at page 77, line 1 to 6, Captain Maseta said the following. When you go to the next column, it is written gender marker or Emada Godin, which tells us the donor of that particular sample, if the donor is a male. If is a male, it will be XY, and if it is a female, it will be XX. In the context of a gender marker, if you have XY, it means that particular mixture, it can be a mixture between a male and a male individual. Or simply terms, it can be a mixture of both or more than one male individual. So, and as well as if you still have that XY, it can be a mixture of a male and a female individual. So when you look at XY on a mixture DNA, you must always remember that XY, it does not mean that that mixture is an only male individual mixture. So in a mixture, that XY represents XS, which is a female, or XY, that is from a male individual. He testified that on the 10th of October 2023, page 2, line 13 to 24. My Lord, it is important that before I start checking whether I find that DNA in the swab or in the head, is that for us to say a person is included, you must have to include the person in all DNA regions. So reading a person in one single region does not mean that that person is included in the mixture. Mr. Prosecutor. Now, what is the position if you read that person in more than one region, Captain Masatla? If you read him in more than one region, you must not, for you to conclude that that person is a contributor of that mixture, we have to read him in all the DNA regions. There was a question by Mr. Malloy to the following. Are there any of these regions or loci that are more important than the others? In other words, that are more distinguishing? Captain Masatla asked that the following. In terms of distinguishing the character of the loci, we use them in combination to give us a distinguishing factor. So we combine them. It is not necessary to say we attach more importance to one than the other. We match importance to the combination of them all together. From what follows from the evidence of Captain Masatla, my Lord, was the analysis and comparison of swab 1, assembly head B, and various reference samples of known individuals, including Josen Mapisa, accused number 4, and he came to the following conclusion. The donor of the following reference sample were excluded as the donor of the DNA on the swab 1, 14DCA H8988, and the head B presumed high friction area PA 3000 788-535, Phosphorus, case 636 of 10/2014. The importance of this report or results, my Lord, is that circumstantially it further excluded my client, accused number 4, in the commission of the offense. The sole purpose for the head to be sent to the forensic science laboratory was in relation to the friction area, whether one look at whether the head has a sweat. Not as what Brigadier Kininda wanted this court to believe. He did his own analysis, which do not find support from the report by Captain Masatla before court. Brigadier Kininda merely says that because the accused, that is accused number 4, is read in one of the regions, then one can conclude that such a report is positive. That does not find support, my lord, from the evidence of Ketchen Masetla. And Brigadier Kininda further testified that because the accused is read in one of the regions, it is possible that he had touched the head. That was not the sole purpose for this head, the exhibit, to be forwarded to the Forensic Science Laboratory for examination. The evidence of Sergeant Vusumuzi Mokhane. Sergeant Vusumuzi Mokhane testified that he is employed by the South African Police Service attached to the National Court Cases Unit. He testified that on the 20th of June 2020 at about 2100 hours in the evening, he was in the company of his colleague, the late Sergeant Mabena, when he arrested Bongani Ntanzi, accused number 2, at Phokeng in Rustenburg. On the 19th of June, accused who appeared before Lieutenant Colonel Rapado for a confession at Moroga Police Station. Accused whose confession statement was admitted as Exhibit HH of the record. On the 24th of June 2020, the accused appeared before a magistrate, Ms. Cronje, for a second confession statement, Exhibit JJ of the record. On the 6th of October 2020, acting on the information that accused who had provided in his confession statement, Brigadier Kininda arrested accused number 4. Brigadier Kininda considered in his evidence in chief that he arrested the accused, that is accused number 4, based on information provided to him, that is Brigadier Kininda, by accused number 2 in his confession statement, that he, Brigadier Kininda, had no evidence against the accused, that is accused 4, before the confessions were obtained. Confessions not admissible against another in terms of Section 219 of the Criminal Procedure Act 51 of 1977. Section 219 of the Act provides that no confession made by any person shall be admissible as evidence against another person. In the Constitutional Court decision of Mhlongo and Nkosi versus the state, which was penned by Justice Theron, the crucial issue, my lord, was the admissibility of extrajudicial statements of accused against a co-accused in a criminal trial. The issues arose in 2 applications in which the applicants seek leave to appeal against their conviction and sentences. The court, that is the Constitutional Court, was called upon to determine the constitutionality or constitutional validity of the admissibility of this statement. At paragraph 18 of the judgment, the Constitutional Court justices find the history of the common law prohibition on extracurricular statements against co-accused. At paragraph 18, I quote the following. At common law, the extracurricular statement of an accused was inadmissible against a co-accused. This common law prohibition stemmed from English common law. In 1832, the Court for Crown Cases Reserved in R. vs. Turner was called upon to pronounce on a conviction for theft. The conviction was based on the evidence tendered in a confession of a co-accused who was an employee of the complainant. The court unanimously held that the confession of an accused was inadmissible against a co-accused and the conviction was thus wrongfully made. Close quotation. A confession of one accused may not even be used indirectly against the co-accused. What is meant appears from the judgment of State versus Batman, 1960, Volume 3, SA 535, capital letter A in bracket. in which case the three accused were convicted of murder. One of them made a confession implicating the other two. All that connected the confessor to the murder was his confession, and all that lined the other two was that the three were in each other's company on or at about the crime of the offense. Although the indirect implication of the other two in the confession was therefore correctly left out of the court's considerations, neither JA found on appeal that they were nevertheless indirectly and wrongfully connected to the murder thereby. The decision based on Wigmore paragraph 1076, an English decision in R versus Turner 168 ER 1298, and the appellate division decision in R versus Nkosi and Zulu 1950 volume 1, parenthesis all, H91 capital letter A in brackets. Batman's case was followed by the appellate division in State versus Robe 1968 volume 4 SA 420A at 425G. A confession may not feature at any point in the chain of inference. Even indirect use of the confession for purposes of corroboration is not permitted. In this regard, see State versus Makeba and another 2003 volume 2 SACR 128 SCA at 133 paragraph 14. It follows therefore that no reliance should be on accused number 2's confession as corroboration of Zungu's evidence, either directly or indirectly. My emphasis.
Family, I'm back again. This is Zebra Family Channel, and I just want to talk about what really transpired in court today. I was really happy at the presentation that was done by Advocate NXUMALO. He was on point, and he was really fighting for his client to be released because he has got nothing to do with the case. He has presented his case in a proper way, and he has articulated the serious points as to why he's bringing up the 174 application in front of the judge to make a decision. Listening to his presentation in court, it made me smile and melt. Like, he's been always sitting down there, and like, at some point we used to have questions as to why he's doing this, and whenever he has to get a chance to interrogate any witness that is in court, he will make a pass. So then when it comes to his client today, what he did in court was amazing, and all the points that he brought up in court. Let's go to the DNA. The DNA, no matter what Brigadier Kininda wants the judge to believe, but according to experts, because he's not an expert on DNAs, so whatever he was spewing in court, trying to change the mind of the judge to understand if any of the ports, say one of the ports is filled out like, okay, it feels like, okay, this person was in that vicinity or in that place of Kelly Kumalo. But the fact is, it has to fill all the 16 ports to make a conclusive. But then it was not conclusive because it didn't fill the ports that it was supposed to fill. As an expert, the expert did explain, and he left a report as to why he is excluding those people. Because all of them were excluded. But because Brigadier Kininda was forcing himself to the judge to understand that this is, because when you deal with professionals, you have to believe them. Don't believe them when it suits you. But if it doesn't suit you, then you don't believe them. That is what Kininda has been doing in court. Whatever evidence that comes from experts, he will pick which one he thinks is good for his case and not good for his case. If it's against his case, then he doesn't go with it. He will try to press on the lies and try to spew it in front of the judge so that the judge can, at some point, they are with people. Every time some people, they will call it an apple and orange. As much as they call it an apple and orange to somebody every day, keeping on spewing the same lies, some minds, they end up changing and feeling like, at some point, maybe this person is right when he is wrong or she is wrong. So those are kind of things that we have to be careful of as we go on. With this case, I was happy with Mr. NXUMALO's presentation. Though the judge had some funny things that he did in court, I was not happy with them. But Rata is just who he is. at some point, because in his mind, it looks like he has the judgment, but we cannot guess what kind of judgment that he is going to bring. But when you listen to his line of intervening when the defense is trying to clear the points or punching the holes on the state side, he is quick to come and remind or to give answers in a very secretive way that you will not understand that he's trying to give answers in one way or the other. So I hope everybody noticed what the judge was trying to do, even before they go for break. What he did before he stood up and go for break, it was shocking. So, family, what do you think about the presentation of Advocate NXUMALO? Do you think he did a good job for his client? I think so, but I will wait for your opinions. As much as you, we have got different opinions in everything, but drop them respectfully and don't forget to like, share, and subscribe. Bravo, bravo, bravo.